Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG's Bulletin Editor. Hello, Dennis.
Hi, everyone. Hi, Helen.
Well, it's all go with consultations, Dennis. Last week, I submitted LLG's response to the working paper on the reform of planning committees, and a huge thank you to our members who helped with that. And this week on Wednesday evening, in fact, is the deadline to the big consultation on standards and conduct. That's a huge opportunity for the sector, Dennis, and very exciting. Both LLG's responses will be available on the LLG website within the Resources Hub. So, Dennis, consultation papers often turn to bills, and we have a new one in the form of the Border Security, Asylum and Immigration Bill, I understand.
Well, yes, indeed, Helen. Provisions that would see unaccompanied asylum seekers treated as adults if they refused a scientific age assessment without reasonable grounds are set to be scrapped by the government. The Border Security, Asylum and Immigration Bill, published on the 30th of January, also includes the removal of powers that allowed for the indefinite detention of children and the practice of the Home Office directly accommodating unaccompanied children upon arrival in the UK. The measures were included in the Conservative government's Illegal Migration Act 2023, but had not yet been implemented. Coram Children's Legal Centre had observed that powers to directly accommodate unaccompanied children when they arrived in the UK without family undermined the Children Act 1989. And it said the Home Office usurping these powers was especially controversial after the national scandal of hundreds of lone children going missing from 7 Home Office-run hotels. Indeed, some of the children have never been found.
Well, in June last year, the High Court issued its final ruling in a long-running case brought by the charity ECPAT UK, which was against Kent County Council and the Home Office concerning unaccompanied asylum-seeking children entering the UK in Kent on small boats. Now, Mr. Justin Chamberlain made clear that Kent County Council cannot depart from its duties under the Children's Act 1989, and that non-compliance with the Section 20 duty is, quote, not justified or excused by resource constraints of any kind. The council had previously eased pressure on its care services through a deal with the Home Office that capped the number of unaccompanied children the council would take, and it was dumped the Kent Protocol.
But in a High Court ruling on the 27th of July 2023, Mr. Justice Chamberlain found the practice to be unlawful. The High Court further ruled that the Home Office's policy of placing children in hotels was unlawful when it became systematic and routine. Welcoming the proposed repeals in the new bill, ECPAT UK said these measures posed a grave risk to the safety and welfare of some of the most vulnerable children in our society, leading to hundreds of children going missing, with 90 still unaccounted for as at the 30th of October last year. Through our legal challenge, ECPAT UK went on to say they ended this practice and highlighted the unlawful actions of the Home Office and Kent County Council in failing to uphold their statutory duty to take unaccompanied children into care, reinforcing the vital role of local authorities irrespective of their immigration status. Helen.
Well, sticking with children, Dennis, a judge has ruled that 3 foster carers are able to bring discrimination and whistleblowing claims, which, if upheld, potentially opens the way for more than 57,000 foster carers in the UK to bring discrimination and whistleblowing claims at an employment tribunal. Now, Judge Crossfield's determination was based on the fact that children in foster care could benefit if foster carers were able to speak up without fear of personal repercussions.
Well, that's right, Helen. And it's important to note that the Equality and Human Rights Commission supported the case. And this is because, historically, foster carers have not been able to pursue discrimination or whistleblowing claims in the employment tribunal. They're not considered to be workers. A Court of Appeal case in 1998, the case of W against Essex, had ruled that there was no contractual relationship between a foster carer and their local authority.
No, that's right. And in this matter, before us, the claimants argued that denial of these protections breached their human rights and left them without an adequate legal remedy. Now, they relied on the rights to private and family life, Article 8, and to freedom of expression, as we know, Article 10, combined with protection from discrimination, Article 14. Employment Judge Crossfield agreed that excluding the claimants from pursuing the discrimination and whistleblowing claims amounted to an unjustified interference with their human rights. Addressing claims that this judgment would lead children to see foster carers as workers rather than parents, Judge Crossfield said, quote, "I do not agree that the existence of these particular rights is inconsistent with the ability of a foster carer to provide a loving family home." And the judge considered that the provision of an effective means of redress is likely to promote the care of children by foster carers.
And in response, Helen, Baroness Kishwa Faulkner, chairperson of the Equality and Human Rights Commission, said, "We supported this case to allow the tribunal the opportunity to clarify a significant grey area when it came to the rights of foster carers." And she added, "Foster carers provide a key service, offering a loving home to children who need it most. They are rightly paid for the essential work that they do." And she went on, "I hope that this judgment gives foster carers peace of mind, that they are not alone if they are mistreated, and that there's now a potential route to a legal remedy." Helen.
Well, it's certainly a case to follow, Dennis, and we will do so. And another interesting case, this time a determination in relation to environmental information and the exemption of not holding that information, Dennis.
Well, yes, Helen, as you know, information law is always in the news. Local authorities deal with thousands and thousands of information requests every week. So it's important that certain issues in processing these requests are clarified by decisions made by the courts. And one issue is, when can an authority refuse an information request on the basis that it simply does not hold the information that has been requested? And the case of Roberts against the Information Commissioner provides clarification on this very question. In this case, it was held that local authority had not been entitled under Regulation 12, subsection 4, paragraph A of the Environmental Information Regulations to decline an information request for a list or map of which roads would be subject to a new 20-mile-per-hour speed limit on the ground that it did not hold the information. And in this instance, the authority held the necessary information, albeit in a different format. It therefore needed to proceed from what is termed raw data.
I understand the reasoning of the court centred on the fact that producing a list or map would not require any particular skill or judgment outside that commonly found within its staff, Dennis.
Well, yes, and where information requested under the regulations could be produced, but only from raw data or what are termed building blocks through some processing operation, then whether the information is actually held by the authority depends upon the complexity of the operations needing to be performed. It also depends upon the degree of skill and judgment necessary if a particular data building block should be regarded as contributing to the requested information. Now, this case will especially be of interest to our members who are information lawyers. Helen.
Yes, and I wonder what impact that might have on, say, requesting information from the government that it holds in relation to a call for evidence. Dennis, I'm thinking here about our remote meeting FOI request. It's an
Yeah,
interesting one.
yes.
But as you say, Dennis, information law is always very topical. Now, back to children again, a small theme of this podcast edition, it seems. And this is the news that over half of councils that support children with special education needs and disabilities have warned they will become insolvent when a temporary accounting measure that keeps spending deficits relating to SEND off their main balance sheets ends next year. And this has been discovered by a survey by the Local Government Association.
Well, yes, that's right, Helen. Councils are currently able to keep what are termed high needs deficits, where the costs of providing outstrips the SEND budgets available to councils. With no clarity about what happens once the mechanism known as statutory override expires in March 2026, many councils have said they will not be able to balance their books when this runs out.
That's right, and the LGA is calling on the government to urgently address the issue in the spending review as part of a wider programme of reform of the SEND system. It says the government should write off councils' high needs deficits, which are projected to rise to 5 billion next year. And this is despite councils being expected to spend 12 billion to support children with SEND. And the LGA notes that whilst the 1 billion funding for SEND announced in the budget was, of course, positive, this money is simply likely to be consumed by partially plugging existing deficits.
Well, yes, Helen, and there's no let-up in the financial woes of local authorities, is there? With the LGA stating that without urgent action in the spending review, many councils will be left with having to make impossible choices on what desperately needed services they can provide. But the opportunity to boost growth may well be missed.
Well, that's right. And Councillor Louise Gittins, she's the chair of the Local Government Association, she said that councils hold the key to public sector reform, which is a clear ambition of government, and that as leaders of their communities and major local employers, they must play a critical role in promoting sustainable and inclusive growth. She went on that we know that there are huge financial challenges ahead for government. However, sufficiently funding councils in the spending review would enable them to fully play their part in leading local growth priorities and unlock the full potential of their local people, businesses and places. Now, in other news, Dennis, I see our corporate partners, Browne Jacobson, have been taking a look at navigating risk.
Yes, indeed they have. Over the years, it has been increasingly recognized, that being a good lawyer, a good legal advisor, is centrally about one thing: understanding risk and then managing risk. It is a subject of wider importance on several levels, of course, not just at a personal level as to the quality of your advice, but also at a corporate, departmental, and operational level too. Risk management should be embedded within local authorities' organisational structure and culture by establishing clear roles and responsibilities and clear reporting lines for this function. So says a report by the Local Government Information Unit and our corporate partner, Browne Jacobson. The report, entitled Navigating Risk in Local Government, Challenge, Change and Capacity, followed in-depth interviews with risk managers in UK local authorities, and it recommends 3 key steps. 1, executive leadership needs to fully support the risk management function to ensure it has sufficient backing and authority, including mandatory risk training sessions for staff. 2, to ensure the future of risk management, a thriving talent pool should be developed comprising young graduates and recruits equipped with the complex skills required, including non-technical and soft skills. And finally, 3, government should develop with local government involvement a shared platform for identifying and prioritising risk areas, such as strengthening local resilience forums.
Well, I took a look at the report, Dennis, and it looks at a growing list of external risks affecting local authorities that it says require careful management, including climate change. That's often off the agenda these days, it seems, or certainly not spoken about as much. Pandemics, cybersecurity, budget pressures, and demographic changes. And amongst the challenges identified by the report is the need to foster sustained engagement amongst councillors and overcome negative perceptions of risk management as a punitive process. Now, Bridget Tatham, who's a partner with Browne Jacobson, she's quoted as saying, at a time of challenge from financial constraints, heightened regulatory compliance, operational issues arising from the drive to commercialise, and the increasing digitalisation of services, to name but a few, the risk manager's role is pivotal to a local authority's ability to meet its statutory obligations and serve its communities effectively.
Yes, indeed. And report author Dr. Andrew Walker, head of research at the LGiU, said, the risk managers interviewed for this paper have largely described a role that relies heavily on communication, relationship building, leadership, and the confidence to challenge at the highest levels. And he added, As a previous joint report had shown about monitoring officers, this role is about people and relationships, as well as demanding a strategic understanding of shifting pressures and how they might impact the work of local government now and in the future. Helen.
Yes, of course, and that report was jointly published by LLG, Browne, Jacobson, and the LGiU, and is still very relevant, so definitely worth taking a look at. Now, let's take a wander over to our colleagues in Wales and a recent article by the Welsh Parliament on rebuilding trust in politics, holding members of the Senedd to account for deliberate deception. Now, this was published last week, taken from the article with lessons for our own MPs and indeed anyone in public service. It states that truthfulness from politicians is essential to rebuild public trust in politics, and the way members of the Senedd are held to account must be strengthened. And this is the conclusion from the Senedd Standards of Conduct Committee. Now, in January, the committee published a report calling for a new recall system, allowing the Senedd to recommend that voters can choose to remove and replace a member of the Senedd if they seriously breach the code of conduct. Now, the committee is going further, calling on the Welsh Government to strengthen the law to prevent and punish politicians and election candidates who deliberately lie.
Helen, this is fascinating stuff, isn't it, compared to the rules and regulations here? And this report is calling essentially for 4 key things. 1, a toughening of existing laws covering the Senate elections, expanding an existing offence to include deliberate deception by candidates in Senate elections. 2nd, it's calling for the Code of Conduct for Senate members to be strengthened, adding an explicit rule to cover deception and for it to be noted online. 3, it calls for more independence when investigating complaints and enforcing the Code of Conduct, and further, to allow people who are not politicians to sit on the Standards of Conduct Committee. And finally, it asks for an increase in the Standards Commissioner's powers, allowing them to initiate their own investigations rather than waiting for complaints to be submitted.
It really is fascinating, Dennis, isn't it? Because it's such a departure from where we currently stand in England. And Hannah Blithen, chair of the Standards Committee, Senedd Standard Committee, she said that toughening rules for members of the Senedd and candidates standing for election is critical at a time when public trust in our institutions is low. The next Senedd election in 2026 will bring big changes to how our Parliament is elected and structured. And she went on, it's only right that we use this opportunity to review the way politicians conduct themselves during elections and after they are elected. And she made the point that the Senedd must represent the people of Wales effectively, and people should be able to trust those who represent them, and that their report is putting forward recommendations to radically enhance the rules and make it clear to anyone who wants to hold public office that deliberately deceiving is not acceptable.
And she also said that by strengthening the law governing elections, toughening our code of conduct and giving more power and independence to those investigating complaints, we can start to rebuild public trust in our political institutions and support a parliament fit for the future.
It's certainly bold, Dennis, and the Welsh Government must now respond to the report and its recommendations. And it's really interesting, Dennis, coming at a time when we are in England examining our politicians at local level, but perhaps, who knows, the national level may be next. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 7, available on the LLG website now. So it's goodbye from me.
And from me too. Bye now.